Salute you all. Thanks for listening. Thanks for always watching. Like the videos and subscribe to the channel. Where you feel that you haven't understood very well, please put your question in the comment section so that we can move on well. And probably still we are under the law of contract, and today the topic that we are going to look at is the topic of we are going to look at invitation to treat. However much invitation to treat is more so put under an offer. We are going to look at invitation to treat and also how we can terminate an offer, termination of an offer. So basically, what you have to bear in mind is that among the rules governing a valid offer, invitation to offer or invitation to treat is not a valid offer. So put that in mind. Where you see invitation to treat, that means that there is no contract and there is no any offer that is rendered on the same. Invitation to treat is merely that you are bringing someone to offer. It is an invitation to offer. That's the good word that you can make you understand. It is an invitation for someone to offer. As we shall see, various categories of invitation to treat, basically. And when you look, one of it we have auction, sell by auction. We know sell by auction probably. They sell something whereby the highest bidder takes the property. You get. And the good case, it was the case of Payne versus Cave of 1789, whereby they were selling what? They were selling a house, and here happens that Cave emerged as the highest bidder. But before they could knock the hammer down, he withdrew, said that I'm not still taking the thing. So they was sued for breach of what? Of a contract, saying that it was an acceptance. But whoever court held that an offer can be revoked at any time before acceptance is what? Is communicated. The mere fact of knocking the hammer down amounted to one acceptance of which they had not knocked it down. That is sold by auction. It's not an offer but an invitation to treat or invitation to offer. Then you have display of goods. Where you display goods, you are merely inviting people to make offers, but you are not offering. The display of goods more so in the supermarkets, more so in the shops. Supermarket more so where there is the price tag of commodities. They are not offering. They are merely inviting you to offer. You get. So basically, if you go in the supermarket and you find that bread is for 5,000, and when you go to the counter they tell you it is for 6,000, basically they are right. You cannot complain that I saw this and this, because you are the one offering, of which the offeree has a right to reject your offer or to accept or to give a counter offer, as you shall see. So put that in mind. There's a good case of Fisher versus Bell under the display of goods, whereby the other one, the display of a knife that was against the Weapons Act by then, it didn't amount something like violation of the what? Of the law, of which it was just an invitation to treat, but they weren't offering the sale. So there's also advertisement, whereby an advert is made. It is not an offer, but merely an invitation to treat. The good case is Kalili versus Kabolic Small Company, where the company made an advert of which that anyone that could use their vaccine and gets influenza was to be compensated with a certain sum of money, of which they deposited even it in the bank as security to make what they are trying to mean more valid or more realistic. Then at the end they missed. You get. Then at the end, Khalil used the medicine and got influenza. So he sued the company for breach of what? For breach. So in this essence, it amounted to a valid offer, since you have seen that it's offer made to the entire world. But the display of goods, it is an invitation to treat, but not an offer. Then you also have mere statements of price. Mere statements of price. What do they mean as mere statements? I'll use the case of Harvey versus Fancy. This case of Harvey versus Fancy, realized that it was a sale of a bumper whole pen, and here the seller said that the lowest price, or the other one that offered to buy, was replied as that the lowest price must be $900. So this it was a mere statement of price, because they say that the lowest price must be $900. So it wasn't the exact price. Basically, they are saying it is just the minimum. So it wasn't an offer, but an invitation to treat. You understand? So we have tenders. Tenders is like you invite people. You make an advert. You invite people to do what? To make offers. For example, company shares. Basically, that is tender. The case of Havel versus Royal Trust, that is a good case of tenders. You get? Tenders are things that are, basically it is like most of also an advert, but I'll use company shares, whereby you invite the company, you invite people to buy shares. So that is tenders. You're inviting people to make offers, different offers on different prices. So that's what I can talk about an invitation to treat or invitation to treat, basically, for you to understand. But invitation to treat is not a good offer or is not an offer. You understand? An invitation to treat does not make the contract binding. So note that in mind. Then we shall go to the termination of an offer. How can an offer be terminated? Or when or how can an offer be terminated? When an offer can come to its end? First of all, by acceptance. When the offeree accepts, then the offer ceases. The contract is done. You get? Then we have also rejection. When the offeree rejects the offer, it also terminates. There's revocation. You have seen it under Section 5 of the Contracts Act. Then we have the counter offer, as per the case of Hyde versus Range. A counter offer, let me give an example of a counter offer. Is like, I offer you to sell to you this pen. I offer to sell this pen to you. Then I tell you I'm offering, give me 500 in this pen. Then me I say that no, for me I'll give you 400. Me telling you that I'm giving you 400, that is a counter offer. That counter offer revokes the original offer. You understand? So note that in mind. A counter offer is like you are giving another price, either lower or higher than the initial price. So it revokes the original or the initial price, the original offer. You understand? That is a counter offer. Then you have lapse of time. Once the offer was made for a month and the month lapses, that offer is terminated. Then there is also failure of a condition to be fulfilled by the offeree or by the offeree. It also terminates the what? The offer. You get? Then there is also death, as the case of Brandberry versus Morgan, where the offeree or the offerer dies. If one of them dies, then the offer is what? Is terminated, basically. So note that in mind, or bear that in what? In mind, basically. You get? So that's the brief I can talk about the termination of an offer and an invitation to treat. So bear the difference and put note. Take keen notes about those things, those key points. So thank you for listening and thanks for being on. I wish you good luck.